Hello and welcome to our lecture on state powers in Printz versus United States. So at this point you should have viewed the lecture on various eras of federalism and read the information in the chapter. And also you should have viewed Peter Iron's lecture on Roger Taney Takes Control. Now, so you should have a sense of the pendulum of federalism swinging back and forth between cooperative federalism from about 1789 through the 1830s, and then back toward dual federalism from the 1930s, from the 1830s through the 1860s, and then swinging back toward cooperative federalism again from the 1860s through about 1895, and then swinging back again toward dual federalism from about 1895 through 1930, and then swinging back again and during the New Deal toward cooperative federalism and expansive federal power from about 1930 through the 1970s. And then in this lecture, we're going to discuss this modern federalist movement back toward dual federalism after the era of expansive federal power in the 1960s and the 1970s. All right, so just to review what we've discussed, we said that federalism is an elaborate arrangement of distributing power between the states and the federal government. Said that the nature of the Constitution was a contract, but we were uncertain who that contract was between. Many argued that it was between the federal government and the states. Others argued it was between the federal government and the people, that the people created the federal government and indeed also created the states. So it's a we the people versus the ratification clause kind of argument. And now let's talk a little bit about the Burger Court and modern federalism. So in 1976, the Burger Court heard a case called National League of Cities versus Usury. And this was the case that signaled that the court was moving back toward a dual federalistic interpretation of the powers of Congress to regulate. Now, this case involved Congress attempting to place regulations on state governments. And while this case it also deals with economic rights or economic issues, it signaled that the court would be willing to consider the 10th Amendment as a bar on federal governmental regulation of states and state business. Now, it is true that just a few years later, the court overturned National League of Cities in a case called Garcia versus San Antonio Transit Authority. But this case, even though it was overturned, led the court to reconsider the relationship between the federal government and the states. So out of nowhere, in this case, the court reversed 3 decades of law, and later the Supreme Court overturned it. But as soon as the Supreme Court decided National League of Cities, 45 states went, hooray! This means that we can challenge the federal government on this test that the court had devised about concerning essential and traditional governmental functions. So the states started to file suit saying, hey, this regulation that the federal government is imposing on us, this is affecting an essential and traditional state function, and they can't do that. In the cases the court took after usury, it chipped away at its decision, it changed it somewhat, but this leads us to what has been called a milder form of dual federalism in recent decades. For example, in New York versus United States, decided in 1992, the court ruled that Congress cannot coerce compliance with the states. It can't force the states to legislate. It can provide incentives for the states to legislate, but Congress can't just simply tell the states, you're going to do this, or you're just going to be all on your own. This case involved the disposal of nuclear waste, which is clearly, nuclear energy involves interstate commerce, but all of this waste was generated at plants in particular states, and so Congress put together a plan that involved incentives to get states to comply with disposal, to create plans of their own. And then at the tail end, the law said, if you don't devise a plan, you are going to, quote, take title to your nuclear waste, and Congress is not going to help you. You're going to be on your own. Supreme Court said you can't do that. You cannot force a state to legislate where its people don't want it to. And that brings us to Printz versus United States, also a Clinton-era case. And this is a case that moves us back toward the Taney Court and the pre-New Deal analysis of the 10th Amendment, or it sort of creates this tension between the Taney Court and New Deal analysis of the 10th Amendment. So, as we said here, in New York versus United States, the Constitution does not allow Congress to commandeer state legislative processes. Well, in Printz versus United States, we had a slightly different situation. And this also involved the federal government dictating terms to the states about policy of national scope and character. In this case, the United States Congress had passed the Brady Bill. It's a bill that placed certain gun regulations on the sale of guns and required that background checks be conducted, and there'd be a waiting period of 24 hours after someone attempts to purchase a gun. And unfortunately, though, there was no national database in place. Today there is, but and there were plans to in 1997 to create this database that would allow someone to submit an application and have that background check be conducted by federal officials, because obviously the sale of guns occurs in interstate commerce, and so the federal government has to regulate it. So President Clinton came up with this idea, and it was written into the Brady Bill, that local law enforcement officials would conduct the background checks until the national database was created. Well, who is a local law enforcement official? Chief law enforcement officers, we call them CLEOs. Who are these CLEOs? Well, they're sheriffs and chiefs of police, right? And who do they report to? They report to mayors and governors, right? They're state officials. Who is Congress to tell these individuals that they will do Congress's job until this database is put in place? Now, the court hears this case. Printz was a sheriff, and he immediately filed suit against the United States. And the question was, does the Brady Bill provision commanding local law enforcement officers to do background checks violate the Constitution? Well, what part of the Constitution? The 10th Amendment. And the court said, yes, it does violate the 10th Amendment by a 5-4 vote. The majority opinion was written by Justice Scalia. And the court reasoned that the 10th Amendment indicates that powers not delegated to the U.S. nor prohibited to the states are reserved to the states and to the people, and that involves law enforcement. That involves law enforcement. Law enforcement is a traditional local function. It's a state function, and the federal government cannot commandeer chief law enforcement officers in counties and municipalities to do the job of federal officials. So that's sort of a modern take on the federalism, the relationship between states and the national government. Thanks very much for listening.